September 12th, 2022. Okay. Okay. I'm going to, that sounds different. Call to order to Monday, September 12th, 2022, meeting of the Oregon City Planning Commission. Before we begin, can we do a quick roll call, please?
Commissioner Bob LaSalle.
Here.
Commissioner Daphne West.
Here.
Commissioner Greg Stoll.
Here.
Vice Chair Mike Mitchell.
Here.
And Chair Dirk Schlagenhofer.
Here. Patty Gage.
Patty Gage.
Here.
Okay.
For the audience, Commissioner Patty Gage is joining us via cell phone.
She's on the phone. Okay. And then Commissioner Staggs did not make it?
Correct.
Okay.
Yeah,
He mentioned he may be able to, but it seems he was not able to. All right.
Right, I don't see him on.
Okay, not a problem. Okay. Before we begin, are there anyone in the audience who would like to make a public comment on items not on the agenda? Not a lot of people here, and I see no comments. Anyone online? Okay.
If there is anyone online who'd like to speak, can you raise your virtual hand? I think we're good.
I don't see anyone. Okay, first item on the agenda, we have two public hearings. The first one is GLUA-21-0045, MAS 21-00006, VAR 22-00001, Park Place Crossing General Development Plan. The record is closed, but we are opening the public hearing for final revisions, and I think Ms. Herdrovich can fill us in a little better on what exactly our job is tonight on this.
Correct. So the record is closed. It was you closed it on August 22nd. The hearing closed as well on August 22nd. So tonight, what you will be doing is looking at the revised conditions of approval and the findings. I think before I continue with any procedural things, I think it would be appropriate to ask if there was any new ex parte contact since August 22nd.
Okay, let's start with Commissioner Stoll.
No ex parte contact.
Okay, Commissioner West.
No ex parte and nothing new to add to the record.
Okay, as for myself, I did get an email from Denise McGriff, and the content of the email was the copy of the adopted Ordinance 07-1007, which is the adoption of the Park Place Concept Plan, but it is the actual adopted version that's recorded with Clackamas County. And that's the only thing I've gotten. We didn't discuss it, but I have gotten that document. And no site visits, nothing new. Commissioner Mitchell.
No ex parte contact since our last meeting, and no changes in any of my other disclosures since then.
Okay, Commissioner LaSalle.
I have no more ex parte contacts. I also received the copy of that ordinance that our chair spoke of.
Okay, and then Commissioner Gage on the phone.
Patty, were you, I don't know if you heard that, we were asking if there was any new ex parte contact since August 22nd.
No, I've had no conflicts of interest, no ex parte contact.
Okay. All right, thank you. Would anyone in the audience care to question any of the commissioners on their statements? Okay, I see none.
Okay, thank you. So as I was discussing, the record in the hearing is closed. The first public hearing opened on April 25th, and we've had about, I think, 5 hearings since then. So over the, oh, I'm sorry. Yeah. have to project a little bit. So since the first public hearing on April 25th, we've had 5 public hearings. The applicant has requested continuances, and over the last 5 months, you've taken in a lot of information and have had a lot to consider. And so at your last meeting then, on August 22nd, is when you closed the hearing and the record and went into deliberations. And during those deliberations, you did add and amend conditions, and I can go through those. And that's essentially what you're reviewing tonight. Did your comments, did your amended and added conditions get adequately recorded? And then we also made findings to support those conditions. So I'm just going to go through the ones that we revised. I think there's 7 of them. So condition number 1 was that we changed the timeline to 12 years. We changed it from 20 years to 12 years for a general development plan and made the applicable revised findings. Condition number 5C was that we added an additional clause that no more front-loaded lots shall be permitted on Holly Lane for any subsequent phases, with additional applicable findings. Condition number 9 was that we reordered the series of conditions in there to make the condition for implementing the phased barrier system kind of its own separate thing that needs to be accomplished and not one of 3 options. Condition 21 was to clarify the review threshold for a type 3 natural resource overlay district. That matches the code. Condition 33 is a new condition, and that was to ensure that future public notices of any amendments to a general development plan or a detailed development plan application, the notice will go to properties and occupants within 300 feet of the Park Place Crossing master plan boundary, rather than the phase boundary that they're working on. And so we added the applicable findings for that. Condition 34 was a new condition specifying the Planning Commission's preferred alignment for Holly Lane that includes the residential lots abutting the existing Trailview subdivision as proposed in the applicant's Exhibit 1 Park Place Crossing layout. And then the last condition, number 55, revised a condition from Development Services to replace wording so that it matches the code. So instead of asking for an analysis of aquifers, we're asking for them to look at infiltration rates of pre and post development. And that was the list of new and amended conditions. So with that, your kind of task tonight is to make a motion if those conditions reflect what your tentative decision was at our last meeting, and if the findings are accurate and fit those conditions. And I guess I want to pause for just a moment, and Bill Kabeisman is our city attorney tonight who's filling in for Carrie Richter, and just see if there's anything else he'd like to add.
No, I think Ms. Hergravich covered it really quite well. The important thing tonight is you're reviewing those conditions, determining whether they met what your deliberation said last week, and hopefully we get a decision here in relatively short order.
Thank you.
Okay, thank you. All right. Before we entertain a motion, anything new, anything we would like to ask Mr. Kabeisman?
Well, I think
Commissioner LaSalle?
I think we need to address this ordinance that's been brought forward for a legal opinion.
That would be good.
Because, that was passed and recorded by the county 2008. And by the definition of an ordinance, it's a law set forth by a governmental authority, or it's an authoritative decree of law, or it's an ordinance is a law passed by a municipal government. So my question is, this concept plan, which is covered by this ordinance, and it's in its entirety isn't covered in appendix or attachment B of that ordinance, legally is the applicant breaking the law by not following that ordinance in its entirety, because there have been no amendments to that law? And would we be breaking the law by saying yes to the development? And I think that's a legal opinion that needs to be addressed.
Commissioner West.
Do you have information I don't have? Or have I overlooked something in my packet in this detail of this ordinance?
Or to ask it another way, do you have enough for everyone?
What is the procedure for handing out an ordinance that was not previously discussed, but it is a recorded ordinance with the county?
So, the fact that it's recorded ordinance doesn't matter too much. What it is an ordinance that's been enacted by the city of Oregon City. As such, it's subject to official notice. You can, you can take into consideration things that are in it, but the fact that there is an ordinance, I don't think affects the deliberations you have tonight about whether or not the applicant met the criteria, which was what the discussion of your at your last hearing. You gave direction to staff that provided what your final input on that. And unless that ordinance is telling you something different about whether the criteria are met or not, I'm just not. I don't see anything that suggests that either the applicant or the planning commission would be breaking the law.
Okay, there's a couple things I'm going to read here that I think are giving us some concern. I'll pass it down afterwards. Like I said, it's an ordinance that we can all read on the website. It's not part of the record, but we use applicable codes and laws every day that are not part of the record. They're just codes and laws. They're not all listed in our decision making. One line here, whereas in a project of this size and scope, additional editing and refinement will inevitably be necessary after adoption. I don't believe any editing and refinement was done to the concept plan after adoption, so are we legally in a place where we should be using it? Next line, further amendments to the Oregon City Comprehensive Plan and Map and Zoning Code and Map will be necessary in order to implement the Park Place Concept Plan. These amendments will be considered and reviewed in a duly noted public hearing, which will be mailed to all Oregon City residents. I believe we did do that, but the one before it that said additional editing and refinement will be necessary, I don't believe additional editing and refinement was ever done.
So what you have is an effective concept plan. I guess it's helpful to think of this in the iterative process of how things happen. This area was brought into the UGB by Metro. Oregon City was assigned the responsibility to develop a concept plan. And then as part of the concept plan, assign certain zoning and comp plan designations. And then you have the general development plan and detailed development plan. So every time you sort of get, more specific about the things that you adopted. And what happened in the concept plan with that clause was the idea that hey, we are planning out here at the 30,000 foot level, and when you get down to the 10,000 foot level, well, you might have to refine it. If in fact no refinement's necessary, and they did a great job at the 30,000 foot level, then there isn't an issue with not going back and readjusting the concept plan. So again, I don't see anything from that quotation that makes me think that there is anything wrong with moving ahead with this ordinance, or with this, what you're considering tonight.
Okay. I think a lot of the problems we had would have been solved by an amended concept plan over trying to make the development fit into a concept plan that the land didn't support the concept plan. So those were the problems we had when we were looking at this law and wondering if we were supposed to possibly amend the concept plan to better fit the property than the other way around. So
Yeah.
I'll leave it at that. I'm going to let anyone continue on with it if they feel there's anywhere further to go with it.
Well, the way I read the ordinance is that excuse me. The way I read the ordinance is any changes to the Park Place concept plan need to be changed by an amendment of the ordinance. And there have been no amendments made to this ordinance, which is a law.
And it says it will be necessary for them to be edits and refinements after adoption. So it says, it says it needs to be done, but it never was. So I guess it's open to interpretation, and I'm interpreting it as it's something that should have been done and hasn't been.
That's kind of the way I read it.
But I'm not a lawyer.
Nor am I.
Can I interject for a second?
I'm
the
sorry,
attorney
but
for-
can you, this is not a public hearing. Are you, I'm not sure, are you
No,
representing?
I'm the attorney for Icon. I just have a quick question.
Yeah, the hearing is closed, I'm sorry.
No, the public
That's
record is
not appropriate
closed.
time.
You cannot take any testimony.
Chair Schlagenhofer, if I might add just my opinion about concept plans. As Bill Weisman was stating, they're usually done at this really high level. And I think putting a clause in there about amending it is kind of like a catch-all, like we may find things later where we need to go back and amend the concept plan. And as it gets implemented, in the case of the Park Place concept plan, it started to get implemented with changes to our zoning code, right, where we applied the zone R5 in some areas and the zone R10 in some areas, and that starts reflecting some of the ideas in the concept plan. And so as it kind of goes through that, it's almost like a funneling effect and gets smaller. That's typically in other cities, I think, the way that concept plans get implemented and get refined that way. They're not usually intended to be implemented in a, like, verbatim, if you will, instance, because the type of analysis that's done at that level has to be refined further. So I would imagine putting a clause like that into the ordinance, thinking that further down the road, there may be a time where we want to revisit the concept plan. But I don't think it makes the concept plan in the way it is today, not applicable.
Okay. I'm not seeing the word may, I'm seeing the word will be necessary. So that's in legal language, when it will be necessary, that sounds like something that will be necessary, not may be necessary.
Sure, I understand. I also haven't
That's
seen this ordinance,
the way it's
so
adopted.
I can't speak directly to it because I haven't personally myself seen the ordinance that you're reading from.
But I may mention that you won't find it in the city website either, because I looked it up in the city website and it's not there. I had to go to the county records to get my copy. So somewhere along the line, back in 2008, the ball was dropped to get it actually recorded on the city website. But it is a legal document with the county.
I feel like the people that adopted this document knew there was going to need to be refinement, because there's no way that they could possibly know that the concept plan was going to fit the land at that time. And it was going to need to be revised at a later date, and it said it will inevitably be necessary after adoption to revise it, and it was never revised.
So another thing to think about is, as we said, you've got the final effect, you're doing the 30,000 foot level. This is one part of a larger concept plan. And it may be that when this gets, whatever happens here may affect what happens next door. This is the first piece. And so, the fact that no changes made since 2008 doesn't make the plan that was adopted in 2008 ineffective. What you have is, the applicant coming in and saying, we're okay with this concept plan, even though it's expected that there'll be some changes. And that is what you're looking at now, is that application based on the concept plan that was adopted is effective. And that, recital doesn't change that fact that the current concept plan is in effect and is the document that currently governs out there.
Okay, thank you. I'm struggling with this. But I'll support what the commission supports, and so I am open to suggestions. Anyone?
So, So, Mr. Kabizman, let me throw out a hypothetical and see if I'm understanding what you're saying. So we also have a South End concept plan. And I assume there's probably an identical ordinance to this one that was enacted when that concept plan was put in place. So if we were to decide, we could as a city decide today, there's nothing proposed for South End concept plan area. We could decide today, you know what? Our objectives as a city, what we want there, are now different than what they were then. So this ordinance gives us the authority as a city to go back and rewrite part or all of that concept plan to realign it to what we want to have happen now. So what you're saying on this one, we could have done that, but we didn't. So the concept plan as it sits and as it was originally adopted is still the concept plan.
That's absolutely right. You said it better than I or Aquila did. That's, that is, where we are.
Thank you.
Well, then my additional comments would be the original concept plan is still in effect, and it's part of attachment B in its entirety, the concept plan. How can we pass this development without the ordinance being amended? Because by the definition of ordinance, if you're not following the ordinance, you're breaking the law. By the very definition of ordinance.
What part of that ordinance are we not following?
The attachment of attachment B, Park Place concept plan.
But we've heard over and over again that the concept plan is the 30,000-foot level, and that it's just a basic idea, and that the actual, what happens on the ground will be different.
Okay, what about the, for example, the density of the zoning? As an ordinance, does it have more weight than basic zoning law? If the concept plan says density needs to be such, is it more binding than any other type of zoning where we have more discretion on the density? Because we compensated a lot for the land that was not buildable, and we granted them more density because of that. Since the concept plan says there's supposed to be so much buildable land and there wasn't, it's technically not fitting the way it was intended to fit. So that's the question.
Can I speak?
Well,
I think Bill's chewing on that. Go
Oh,
ahead.
Bill's chewing on it.
There are violations of the Park Place concept plan. Number one, it states 2 primary north-south connections between Holcomb Boulevard and Redland Road, references those. It references existing low-density clusters. Properties along Holly Lane are expected to remain as low-density clusters. And I can go through several other areas in the Park Place concept plan that are in violation. The developer is in violation of those parts of the
Through the
concept
variances.
plan, so they are in fact in violation of the ordinance. Since the Park Place concept plan is attached as the ordinance.
Mr. Kabaisanen.
I'm still chewing through it. I would defer a little bit to Ms. Hurd-Ravitch, who, as you know, Ms. Richter is one who has been shepherding this project through, and Ms. Hurd-Ravitch may have more familiarity with the issues that are coming up about consistency with portions of the concept plan. And so if Aquila can speak to it, that might be helpful.
Yeah, certainly. So I think the concept plan envisioned multiple different types of densities. It talked about R5 as a new density that wasn't part of our zoning code at the time. I think it talked about R3.5, which is a higher density than R5. And it also talked about R10 and lower densities as well. So it envisioned a range of densities, and that is what got adopted as part of the zoning code. So the land, when it was brought in and annexed, also got zoning applied to it. And that zone of R5 is reflective of what the Park Place concept plan envisioned. It could have been zoned at R3.5 because the concept plan envisioned that as well. So that piece kind of already happened. And when the master plan that is before you and that you've been discussing for the past 5 months came through, the eventual density reflects that R5 density. And that's kind of what we had gone through at the last meeting where we talked about what is the minimum? Because I think you asked a really good and clear question in one of our meetings of what exactly is the minimum density and what exactly is the maximum. And that's based on looking at how the land is already zoned. So there's R10 and there's R5 in there. And both of those reflect what's in the concept plan. And the zone that the density that the applicant eventually landed on is in the middle of the minimum and maximum.
Okay. I remember one of the things I brought up early was with the land not matching the concept plan exactly, the buildable lot sizes got smaller. And that's where a lot of the variances requested came from, the ones we're discussing tonight. And And I asked Miss Kelly Reed at the time, there's got to be some kind of a bottom to it. We couldn't have a concept plan for an area that's 91 acres, find out there's only 10 buildable acres, and then possibly fit all those units in the remaining 10 acres. And she said that there was no minimum. And I don't know what meeting that was, but that's what she said. There was no minimum lot size. But clearly that makes no sense. That we can't put that many units in 10 buildable acres if that's what we found. That's not what we found, but that's what the answer was. And I think at that point, that's when the concept plan would have to be amended. Because clearly we don't have what we thought we had. And we don't have that drastic of a situation, but it's definitely it's a situation where the concept plan and the land and reality don't match. And it makes us wonder if the concept plan should have been amended. And I have no idea where to take that.
It maybe should be amended going forward, but we're
deep.
yeah, I mean, going forward for this development is not the entire concept plan area.
Yeah.
So it may need to be amended for the next section for the South Village or the remainder of the North Village, but.
All right, knowing what we know now, Mr. Kabaiseman, what could be done in the future with the concept plan now that we know that there's a lot of land constraints we weren't expecting, and it really needs to be amended?
I think your fellow commissioner hit on it to the extent there is significant issues with that concept plan that we've identified. Maybe it would be to go back and take a look at the concept plan and see what makes sense given the constraints that we found on the ground, as well as the constraints that the city's under with Metro, and take another look at the concept plan. But that's unfortunately not in play with this application.
Okay. All right. I can live with that. Thank you. Okay. Commissioner Mitchell.
Just one small point. Condition 9A, as it was revised, still mentions, that's on the phased, the bollards and the phased traffic access. It still, as written, mentions a 2,000 trip cap. And my understanding was had nothing to do with any number of trips. It needs to be implemented. So I would like to see that condition wording changes. So it just said that that phased bollard plan will be implemented.
Okay,
I don't have
we can strike that.
Yeah.
Right.
Is that direction from the rest of the commission?
I agree.
I agree.
Yeah, that works for me.
Thank you.
Okay, any other concerns on any of the other conditions? Okay. I guess we're ready for a motion.
Are we going to have further discussion about the development? Deliberation before a vote? There normally deliberation before a vote?
The deliberations were part of your meeting at the last meeting when you added conditions and amended conditions.
Yeah.
So we're
the
not allowed
record-
further deliberation?
No, we can discuss, because we had the tentative approval, we can discuss the conditions of approval in the staff report.
So as I understand it, what we're doing tonight is that the only thing we're voting on is that these additional conditions match what the majority of the Planning Commission voted for last time.
Correct.
That's all. We're not adding conditions. We're not changing anything. We're merely rubber stamping that the things that we said verbally in the last meeting have been accurately recorded in writing. So if you have concerns that what was voted upon in the last meeting doesn't match what was written, then we can bring those up. But beyond that, what's done is done.
Yeah, correct.
only thing we could discuss at this time would be the conditions of approval that were discussed before.
Yes. Do you have those?
Insofar as they do or do not match the direction that we gave at the last meeting.
Well, all right.
Are we ready for a motion?
We are ready for a motion.
I move to approve the Park Place Crossing General Development Plan, GLUA-21-000045, MAS-21-000006, and a variance BAR 22-000001 tonight.
Okay, we have a motion. Do we have a second?
Second.
Okay, a motion by Commissioner West and a second by Commissioner Stoll. Can we call a vote, please?
Commissioner Bob LaSalle,
No?
Commissioner Greg Stahl,
Aye.
Commissioner Daphne West,
Aye.
Commissioner Patty Gage,
Aye.
Vice Chair Mike Mitchell,
No.
Chair Dirk Schlagenhofer.
No.
So Bill,
Motion fails. We need a
I
new
believe that
motion.
means the motion fails.
There's only 6.
Well, we have a commissioner leaving, so we make the same motion and be what it'll be.
Commissioner LaSalle, we need another motion.
What?
The motion failed. No, we only have 6 commissioners. Commissioner Staggs is absent. It was a tie.
I guess I misunderstood the voting. I thought that Commissioner Mitchell and I were the only two that voted no.
I also voted no.
Who's that?
Commissioner Schlagenhofer voted no.
Oh, I'm sorry, I misunderstood. Okay.
So a tie vote?
Before we do that, highly unusual that a commissioner would leave in the middle of a meeting. Did you have a personal emergency, Commissioner LaSalle, or what was the purpose of that?
No, no.
What was the purpose of leaving?
I don't think that this commission has fully considered the ramifications of this development. I don't think that this commission has considered the information that's contained in the handbook for planning commissions as put out by the state for a fair and impartial consideration of all parties, not just a developer, and that the overwhelming testimony from the citizens has not been duly considered. I mean, have you ever in your life, in any commission meeting, and I don't mean just planning commission, but I mean city commission meetings, ever seen such a response from citizens? I'll guarantee you, never.
And how was that addressed? By your getting up and leaving?
Okay.
Because with a no vote, I'm just,
Okay, here's another question.
What it amounts to.
Commissioner LaSalle, Are you ready to continue the meeting?
Pardon me?
Are you ready to continue the meeting?
Yes, I'm ready.
Are you okay with that?
If I had the bylaws in front of me, I would move to have Commissioner LaSalle removed for failing to do his duty by leaving in the middle of a meeting for no good external reason, but I don't have a copy of those bylaws in front of me.
Mr. Kabaizaman, if a commissioner is compelled to stand up and walk halfway out and then is persuaded to come back, where does that put us?
So a commissioner can leave a meeting and return. The question really is, what do the bylaws say about the actions of a commissioner? I don't have a copy of them in front of me, but if you give me a few minutes, I can track them down. But I don't think it requires the commissioner not participate in the meeting. There may be some options for the commission to remove a member for certain types of conduct. Like I said, I just don't have that in front of me. If you give me a few minutes, I can see if there are any options like that. Perhaps,
We can take a 5-minute break.
Okay.
And then, before we do that, I just wanted to ask, do any other commissioners feel that Commissioner LaSalle is not performing his duties as a commissioner?
I think it's inexcusable to walk out during the middle of a meeting.
I'm not going to judge somebody else's actions.
It's an emotional meeting. It's an emotional topic. I'm gonna see what Mr. Kabaizaman comes up with, and we'll take a 5-minute
So
break.
I actually have the bylaws in front of me.
Okay, save us from taking a break.
Yeah, and there is, upon failure of a member to attend 3 consecutive meetings, the planning commission may recommend termination of the appointment to city commission. All members serve without compensation.
Are those the bylaws that we recently adopted? Because I think the 3-meeting thing got taken out, didn't it?
You're right, this is the 2000 era bylaw. It is not the current one.
So Bill, I tried to email them to you and it just bounced back to me. I'll email you a link to the new bylaws right now.
I think I've got them now, yeah. They're dated August 22nd, 2022.
Correct. That's the correct date.
Yeah.
As far as I remember, our bylaws said we can recommend it, but it's up to the city commission to enact it.
Yeah, and that may be correct, and I don't recall the specifics. I don't have it in front
And
of
it
me.
requires a public hearing.
Ultimately, it's the city commission that has the authority to remove or not remove a planning commissioner. I don't think there is any steps that the planning commission can take at this point, other than general meeting management that is in the discretion of the chair pursuant to Robert's rules.
Okay, I'm ready to continue the meeting. If the other commissioners are ready? Okay.
Yes.
We need another motion. And then if we can't come up with another motion, then we need further legal advice from Mr. Kabaizaman.
What other motion is there to make?
Yeah.
I mean, if what,
We've got 2 options. There's 2 options in the staff report. We got an option for approval, we got an option for denial.
Let's see.
We got 1 and 2. We got number 1, number 2. But the question is, if we can't agree on either one, then where are we at?
Right now we've had a motion for approval that failed because of a tie vote, 3-3. We haven't seen if a motion for denial would succeed or fail. Presumably if the votes stay the same, it would fail as well for failure to get a majority. At that point, there are, somewhat limited options. One is if a planning commissioner were to leave the meeting, that would change the math. If the absent planning commissioner could be contacted to appear and were able to make it, that would change the math of the meeting. Otherwise, there could be discussion among the commissioners to see if there is some reason why a commissioner would be willing to change their vote, whether through convincing that the current one, you know, should be done differently, or, you know, additional discussion among the planning commission. To the extent there is no motion that can succeed, I want to take a quick recess after further discussion with the planning commission to look into what happens on a failure to reach a decision. I believe what happens is it gets continued to the next meeting, and hopefully we'd have a full complement at that point.
Okay.
Or a commissioner could choose to recuse themselves.
Okay, let's start with another motion first. Would anyone care to make a motion?
A move to approve with additional findings, GLUA 21-00045, MAS 21-00006, and VAR 22-00001.
Do we have a second?
I'll second it.
Okay. We have a motion by Commissioner Stoll and a second by Commissioner West.
I'm sorry to interrupt, but was that, I didn't hear exactly what your motion was.
It was a repeat of Daphne's motion.
Okay. And I'm sorry to interrupt again. It looks like, thank you, we have Chris Staggs on the phone.
Maybe he was watching. Okay. Is Commissioner Staggs prepared to vote on the motion?
Commissioner Staggs, can you hear me? Oh, let me turn it. Can you say that one more time? Can you hear me? Okay, so for the record, Commissioner Staggs has joined us at 7:53 via an additional cell phone. And I don't know, Commissioner Staggs, I don't know if you heard Commissioner Stoll's motion. So maybe Commissioner Stoll can repeat the motion and we'll try that again.
My motion is to approve with the additional conditions, GLUA 21-00045, MAS 21-00006, and VAR 22-00001.
Okay. And we have a motion, and we have a second. The second remains. So call to vote, please.
Commissioner Greg Stahl,
Aye.
Commissioner Daphne West,
Aye.
Commissioner Bob LaSalle,
No.
Vice Chair Mike Mitchell,
No.
Chair Dirk Schlagenhofer,
No.
Commissioner Patty Gage,
Yes.
Commissioner Chris Staggs.
Yes.
Pass.
Motion passes. Okay. Next item on the agenda, GLUA-2. I guess we want to take a short 5-minute break before our next agenda item. 5-minute break. Okay, we are back from break. Oregon City Planning Commission, going on to public hearing number 2, which is GLUA-22-0000. I hope that was 3 zeros. 15 SP 22-00050, VAR 22-00002, FP 22-00002. Planning Commission variance request to the rear yard abutting a residential zone to allow for the relocation of existing non-transitory? I thought that was a different word. Non-transitory mobile food units and a minor site plan for a 250 square foot rear addition to the main building on site on property located at 504 14th Street. Since this is a quasi-judicial hearing, I have a quasi-judicial script. Do I need to read that even if there's nobody in the audience? Okay.
Yes.
Because somebody could watch it later. Okay. One public hearing on land use applications is scheduled tonight. Our role is to conduct the public hearing and to make decisions about the matter before us. And making those decisions, we must apply the applicable codes and laws and cannot vary from or change those laws or codes. Members of the Planning Commission are to be unbiased. Before the start of the hearing, I'll ask the Planning Commissioners whether they have any potential conflicts, such as family, financial, or business relationships with any of the applicants or with regard to the land in question. I'll also ask whether any of the Planning Commissioners have discussed the application in question with any other parties or have independent knowledge of relevant facts, such as from a visit to the site in question. Any member of the audience may question any planning commissioner about their disclosures. A staff report has been prepared for each application, has been made available to the public 7 days before the first public hearing. The staff report identifies the approval criteria that apply to each applicant's proposal. Staff has analyzed the criteria which are contained in the staff report. The quasi-judicial hearing procedure that the Planning Commission will follow is set out in state law and the Oregon City Municipal Code. The hearing procedure steps are shown on the Planning Commission website and on the door on the wall. Public testimony will be called on in the order it was requested in advance of the meeting. If you have not emailed city staff at planning@orcity.org to request to speak and would like to testify, please raise your virtual or physical hand when I ask if there's others in the audience who would like to participate. For the public record, please begin all testimony stating your name and city of residence. If you'd like to receive a copy of the notice of decision, please state your mailing address or email address. Testimony and evidence should be directed towards the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, identify and discuss those criteria and explain how and why you believe they apply to the application under consideration. Any person may submit written material while the public record is open on each application. Any written materials received by the city staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the city staff in order to become part of the record. If a person intends for PowerPoint presentations, reports, pictures, or other exhibits used in their oral testimony to be placed in the record, copies must be submitted to city staff while the record is open. If they are not given to staff, they will not be included in the record. Any person wishing a continuance to present additional evidence and testimony or to keep the record open to respond to new evidence must make that request before the public testimony portion of the hearing is closed. If the Planning Commission makes a decision with which you disagree, any issue that you may wish to appeal must have been raised on the record for the consideration of the City Commission or LUBA or both. Without raising the issue on the record with sufficient detail and accompanied by statements or evidence that the city and all parties can respond to, the issue will not be deemed appealable to the City Commission or State Land Use Board of Appeals. In addition, the failure of an applicant to raise constitutional or other issues relating to the proposed conditions of approval with sufficient detail to allow the local government or its designee to respond to the issue precludes any action for damages in circuit court. Now, we will open the record for Oregon City file number, GLUA-22-00015, SP22-00050, VAR22-0002, FP22-00002, Planning Commission variance request to the rear yard abutting a residential zone to allow for relocation of existing non-transitory mobile food units and a minor site plan for a 250 square foot rear addition to the main building on site on property located on 504 14th Street. We will now ask each planning commissioner if they have any ex parte contacts, conflicts of interest, any bias, or any other statement to declare, or have visited the site. I will start to my left with Commissioner Stoll.
No bias, no conflicts of interest. I made a site visit the last time this property came up for a hearing, but I didn't make one this time. However, I drive by it many times a week, and I've kind of glanced over there during my drive-bys.
Okay, thank you. Commissioner West?
I have no bias, no conflict of interest, and I have not been by the site since we talked to, or the previous one was voted on, and I can't remember how long ago that was, but I haven't been there, I haven't visited there.
Okay, yeah, I'm not sure either. It feels like it may be around a year.
Is it that long ago?
Less than a year.
Okay, I take that back. I have eaten there within a year.
Okay, Commissioner Mitchell.
No ex parte contacts, no conflict of interest, no bias. I did take one for the team. It was difficult, but I did make a site visit. The only impression I had was the two houses at the top of the hill were a little closer than I thought they were, but not enough to really change my opinion on anything. That's it.
Okay. And as for myself, no conflicts of interest, no bias, no ex parte contact. As far as the site visit, I've been there several times, but I wasn't looking at specifics about the site. I will say that Ms. Herdrovich sent me some photos today because I had questions about the stairs. And I also had questions about the location of the mobile food units to the property line. And that was the extent of our discussion. And there is nothing else I can think of bringing up. So is anyone in the audience, would they like to question any of the commissioners or myself on our comments? We are running out of people in the audience. Okay, we have no concerns. I believe we are going to be hearing the staff report, and I think this is going to be Ms. Robertson Gardner.
That's correct.
Thank you.
All right, we'll load the presentation up. Let me know if you can't hear me. Sometimes my voice starts loud and then gets softer through the presentation, so feel free to let me know if you can't hear me.
Sounds good.
All right. So as Chair Schlagenhofer mentioned, that was a very long title, but the applicant has two applications really combined. One is the variance request, and one is a small addition to the rear of the property. And I'll go through both and provide findings and recommendations and potential conditions of the approval that the Planning Commission can review. So you have three options tonight: approval with conditions of the application, or approval with revised conditions if the Planning Commission wants to provide any revisions, denial of the application, or continuance of the application to a future meeting. The next available one is October 10th. So as I mentioned, there are two applications really combined into one proposal this evening. The Planning Commission variance, which the majority of my presentation will be related to the type 3 request, which is, involves discretion, involves a public hearing. It requires the Planning Commission to make findings for compliance with variance findings in our comprehensive plan. The second piece would normally be reviewed under type 2 planning review and approved by the Community Development Director. This is a floodplain review for, as well as a small minor site plan for the addition. Those are normally type 2 applications, but the applicant chose to combine both applications. So with any motion this evening, your motion will be related to both the site plan and floodplain portions as well as the variance request. I'm going to go next. So a little overview of why we are here this evening. Didn't we just review this last November? I think I was hearing a little bit about that, so let me go over why we are here this evening. So in November of 2021, the Planning Commission approved a variance to the rear yard setback in the area abutting our residential zone, which is a requirement in the mixed-use downtown zone that there needs to be a 15-foot setback between the property and any residential zone. And with that application, the applicant was presenting a covered seating area in the location where they are choosing to provide a new proposal, which is rearranging the existing food carts on the site and proposing to put the food carts where the approved but unbuilt seating area would be. So the applicant is not proposing to move forward with the covered seating area, but now is coming back here with a request for a variance to put the food carts in that same location. Let's see. Food carts could have a different impact than a seating area. Staff felt that a new variance in front of the Planning Commission, a new hearing, was required for this application. Along the same lines of the application that came to you in August for the heliport, there's enough change from the original proposal that it warranted a public hearing. Impacts are really what variances and conditional uses are looking at, and so when you're looking at site-specific impacts, you want to make sure that there's the ability for the public to comment in a public hearing for a discretionary review such as this. So I'll do next. In general, let me go to my staff finding. So let's see. As I mentioned, a public hearings process is required for type 3. We received one public comment for this during the whole time it's been noticed. It was related to an existing light standard that's on the site, the far northeast part of the property, kind of towards the intersection of Center Street, near the trestle. And normally there's a requirement for lighting to not shine off site and to shine down. It looks like a car hit the light standard and it shifted the light, so it's now shining towards residents on Washington Street. That can be pursued through code enforcement of not meeting our lighting standards, but also it is seen as an impact, so staff added that as a condition of approval for the variance. Let's see. Planning Commission did approve last November the previous variance request. Staff found that the noise and sightline impacts are not found to be demonstrably different than the previous variance, so this is really up to the Planning Commission to decide if that is the case this evening. The applicant proposed some mitigation tree planters in the previous variance application, kind of between the building and the parking lot on the kind of other side of the site near Center Street. They're still proposing to move forward with those mitigation planters with this application. Once again, there'll be a condition for the existing light standard to be realigned to shine downwards, and staff found the applicant provided sufficient findings for the variance request. Chair Schlagenhofer brought up two comments today when he was talking to our Community Development Director. One, there was a typo in one of the pages, I apologize. It mentioned 2 inches and then not 2 feet. The applicant is requesting a 2-foot variance, so I apologize if there was a sleight of hand typing. It was not intentional.
I thought you were really getting down there, really close.
No, it's a 2-foot variance request. And secondly, there was a question about some rock stairs that lead from the property on 13th down. And if the applicant, I'll let the applicant speak this evening after my presentation. If the owner of that property on 13th has a legal access to access the subject property, then there could potentially be a condition of approval to add to make sure that there's at least a 3-foot clearance between food carts to allow that access. I'm not aware if there is actually a legal access. I'll let the applicant speak. If there's not a legal access between the two properties, I don't think that the additional condition would be warranted as part of this variance request. So I'll let the applicant speak to that. See next, just to provide you some background. This is, This was an existing property that was rehabbed a couple years ago to be a non-transitory food cart pod, and we separate our food carts into, or mobile food units to be very technical, into transitory, which means you're there no more than 5 hours a day, and non-transitory. So this is kind of in general terms, a food cart pod is where you have non-transitory carts. And so this is a non-transitory food cart pod that was rehabbed from an existing commercial property on site. It is located in the mixed-use downtown zone outside of the design district. So it has a height limit of 75 feet, maximum and a minimum height of 20 feet related to non-accessory buildings. So the small addition and this food cart or the seating canopy you had are small accessory buildings that don't have to meet that 25-foot minimum height limit. As you see, it's also abutting the area in Brown, and that's a residential zone, and that's why we're here tonight. If this property was completely surrounded by mixed-use downtown, there would be no minimum setbacks. This property is also located in our flood overlay district. It flooded both in 1996 and is in the 100-year floodplain. And so as part of the minor site plan design review for the addition, it will be subject to our flood overlay district code. And if you can see from the conditions of approval in your staff report, those conditions really relate to our building official and his capacity to ensure that when permits are received, that they meet our flood overlay code. So staff, I separated the conditions of approval in your staff report to items related to the development of the rear addition and the flood code related to that. The building official does not see the mobile food units as subject to the flood overlay district. So they will need to just leave prior to any flooding that may happen on the site. As you see from the site plan, I have two arrows. The top arrow shows the new location of the addition to the rear. This is a storage area. For the most part, it is an extension of the roof and some poles, and then a wood fence that surrounds it to allow the site to do some storage of seating or other areas. The reason why you have just a roof, some poles, or some not walls, is it's been designed to be a flow-through during a flood event. So it is really just a canopy with a wood fence surrounding it, and that is what our building division and building official will be looking through. The area in the lower part with the blue is the new location and the reorganization of the existing food carts. That was the location of the seating canopy. And some of the reason the applicant will talk about in the presentation, but from what I understand, this reorganization really allows each food cart to leave independent of each other. So I kind of akin to call like valet parking versus drive in and out. So in a flood event, there's less coordination between or either a flood event or mobile food units leaving or coming on the property. You know, the life of a food cart will have many different food carts over its time. Some will succeed, some will fail, some will find a new spot. And so moving those carts in and out, the applicant identified this was a better layout to do that, to make it more independently accessible. So real quickly, just to explain why the applicant is requesting a variance for food carts, because normally we do not consider vehicles subject to setback. So you could have a parking lot in your setback and vehicles parking, and that would not be require you to meet your setbacks. It's only structures. And we do not consider vehicles or trailers, like a food cart, to be a structure. But in this specific situation, I want to identify for you. So what you see on your screen is the non-transitory mobile food unit code. In the last area of the standard, it says non-transitory mobile food units must comply with the minimum setbacks of the zoning district. And so vehicles are normally not considered structures and generally not subject to the setback requirements unless specifically stated in the code, such as what you see above. So really what the Planning Commission is looking at is a site-specific analysis if allowing food carts into the setback will adversely affect the neighbors around them, and have they met the variance request that's being, the variance finding that's being requested this evening. So to provide a little more background, to the left, the applicant provided kind of a site study that shows the location of the houses on 13th, along with the contours, and then a side view with the food carts down below. To your right, just shows the side elevations. I put arrows showing the small addition in the back for the storage area. And this is on the main building. So at top, you'll see, this will be what you're looking at if you were at the food carts and you're kind of looking north towards the building. And the view from below is you're actually in the parking lot, kind of near the trestle, looking back at the main building. So some background photos. If you're on Washington Street, where the arrows are is the general location of the requested food cart to be located. Here's just some site views from 14th Street. The arrow that I'm showing looks to be the light standard addressed by the public comment. So I'll let the applicant know if that's not the case, but from what I could see from the public comment, this appeared to be the light. And then the last one, the comment about the public stairs. And so what you see on the left is a 2019 Google Map view, and it's more visible because there are no food carts there. But if you click on the 2021 mobile food cart, it's hard to see, but they are there. Nothing's changed, it's just harder to see. So I wanted to show the 2019, and it shows kind of hand-built stone stairs that move up, but it appears they don't go all the way up where there's a lot of vegetation, so I'll let the applicant speak to that. So at this point, I did not put the site plan and design review conditions because they're very specific related to our building official, but I have two conditions related to the variance request. One is the applicant shall ensure that the existing light standard on the northwest corner of the site is repositioned to shine downward, not cause glare to the residents on Washington Street. And the applicant shall ensure that the proposed landscape planting proposed in the last application, which was the GLA 2144, is installed prior to obtaining final building permit approval. So those are the two conditions I have related to the variance request. And at this, through this presentation, speaking to the applicant and deliberations, the Planning Commission determine if these conditions are sufficient or you want to add additional conditions for this request. So I am available for any questions. Have your options again. Approval with conditions either as proposed or amended, denial of the application, or continuation to a future meeting.
Just one question. In condition 6, where are those planters that
sure, and I'll go
are
back
not there now?
Yep. I will go. Is it? Can I go backwards? Oh, there we go. I'm going to go. Do you see, and I can't, maybe Cindy can help, to the just north, well, upwards, it's not really north, but upwards of the top small arrow? If you go up, can you see if you find the smaller arrow, yep, and go just directly up. Right in that section is proposed additional larger planting areas. Mm-hmm. So I will have the applicant speak to that.
Quick question. To your knowledge, has the adjacent landowner made any claims of access or anything regarding those stairs?
I have heard nothing from the abutting applicant.
Thank you.
The abutting property owner to
Correct, yeah, understood. Thank you.
I guess I do have one more question for you. The 2 handicap spaces, is that per code? Because that doesn't seem like very many for this size of development, especially since the last 2 times we've tried to use them, there were none available.
So the building official actually implements handicap spaces. This went through site plan design review, and so based on the proposal, the building official identified the minimum number of spaces. So I'm not the building official, but I do know, and we don't review it on planning, but if this went through site plan design review, the building official applied the criteria for the minimum amount of handicap spaces.
Okay, thank you.
Commissioner West?
Ms. Robertson-Gartner, did I understand that the canopy we approved previously had a 2-foot setback exactly the same as?
Sure, the variance was to allow up to a 2-foot setback, so I don't know the final location, but the applicant is requesting the same level of.
The same, so it's basically the same.
But in this situation, we went from seating canopy structure to food carts.
Correct.
So different uses in the same variance request
Right.
location.
Same distance. Thank you.
Okay, any other questions?
Yeah, I guess while we're on parking, will the total number of parking spaces also be something that is part of the building official review?
No, and that actually was in my staff report. The applicant is not proposing to change the number of food carts. The number of parking spaces is based on the previous site plan design review they are between their minimum and maximum parking spaces for the site.
Okay,
So actually, I think they actually might even be at their maximum for the site.
Okay, because this is going to lose 2 or 3 spots. The locations where what are marked as cart 1 and cart 2 are parking spaces now. You can see them on one of the pictures that you showed. I think it was the next to the last picture, maybe.
This one?
No, one more. There, the picture on the right. See those picnic tables back there up against the?
Yep.
They're actually in parking spaces.
Okay, well, we'll let the applicant speak, because per the presentation, there was no proposal to change
Okay,
their parking.
and that is one of the locations where carts will be.
Correct.
Okay. Okay, maybe they can speak to that.
Sure, and I do know, per the last staff report, they were either at their upper end of parking, and they definitely met their minimum parking, and they may be at their upper end to their maximum parking,
Okay.
but I'll let the applicant speak.
Okay, thank you. Now I'm done.
Okay, I'm going to ask a question based on Commissioner Mitchell's question. Could a property owner voluntarily add a handicap parking spot if they have a lot of handicapped customers?
I believe they can, but they would need to work with our building official to make sure that space meets the requirements of the building code. So just because you want to make a space handicapped, there's specific requirements of slope, location, size.
Yeah, sometimes you need 2 because you need to give them a place to unload. So you actually lose 2 spots to add 1 spot. Okay. All right. Okay. No more questions for staff? Okay, then we will now hear from the applicant, and you have up to 15 minutes if you need it, and please state your name and city of residence.
Hello, thank you very much for having me. My name is Derek Metzen with Green Box Architecture, located at 502 7th Street here in Oregon City. So,
We're getting, the applicant has a slide. We're going to get ready, sorry.
okay, yeah.
Technical
To start,
difficulties.
if it would be helpful, we could go back to that section cut.
Sure. Oh, do you want to stay on my presentation then? for the
Yeah,
time
let's
being?
stay
Okay.
on yours for the,
All right,
for the
so-
time being.
Oh, you're going to have to hold on.
Technical difficulty, sorry. I think we need to stay on my presentation.
now they
Oh, here we
are.
go. It works.
Oh,
There we go.
great,
Well,
great.
But it's not sharing. I don't know.
No.
It's absolutely fine. So I heard a couple questions there, and I'll just address those to start with. Let's start with the stairs. A title report has been pulled on this property. There are no encumbrances. There is no easements provided to the property to the south, and there is a staircase there, but there's no legal means of egress or use of the subject property. ADA parking. So one ADA parking space is required for less than 25 parking spaces in the parking lot. Between 26 and 50, 2 ADA parking spaces are required. And we fall within that threshold that only 2 are required. In fact, on the lower end of that threshold. So we meet both those requirements. Talking just briefly about the addition that's proposed. It is largely an outdoor venue. I think we've all been there and enjoyed it. And some of those games and seatings during inclement weather needs to get out of the rain. And so rather than have unsightly storage or exposed storage, the desire is to enclose a small portion underneath the covering so that storage can be on site but out of view from the general public. It's roughly 8 by the width of the building. It's directly adjacent to some existing storage. That's a beer cooler on the south side of the facility. And so it's tucked out of the way. It's painted to match. And it'll be very discreet. The 5 food units, non-transitory food carts that are there, will be relocated. And as Christina mentioned, they'll be located in the same place that the awning was previously proposed. The initial concept design was that we'd have 2 seating areas, one larger, robust, full of conversations. The one that was set back behind those 3 food carts that dissected it would be allowed for more kind of quiet conversations. What we have found over time is that staff has a hard time supervising some of the interactions that happen on the south side of those 3 food carts. We have also found that there are some logistical challenges moving food carts in and out. So by relocating those 3 food carts to the south property line, what we gain in a flood event is non-scheduled egress from the property. A part of the original land use approval was that in the event of a flood, to prevent this property for increasing the flood elevation for adjacent properties throughout the city, those food carts would be removed so we're not displacing water with those food carts being placed in the floodplain. That being said, in a flood event, it's a little chaotic, and we don't want to prohibit anyone from leaving if they're able to. So by moving those food carts further south, we're able to accommodate that a whole lot better. Just logistically and practically speaking, first person with the truck that arrives, get your food cart out. That being said, let's talk about the impacts and what makes this particular development unique. A variance is approvable if the impacts are mitigated in some way. If the proposed alternative is equivalent to this standard. So, the Oregon City Municipal Code, the zoning code, assumes that properties adjacent to each other are flat. As we know in many places in Oregon City, properties are not flat, and this is one of those. In fact, we have a significant geological slope that occurs directly south of the subject property. As we look at this section cut here, it doesn't show on the screen there. My laser pointer fails, I apologize. As we're looking at this section.
You can ask, maybe, can we?
It's okay. You can see a diagonal line that kind of cuts through the section. The gray portion on your screen is the earth that's cut through. Please go back to the previous slide.
Do I script? Sorry.
Okay, there we go. The house is drawn to scale. The little box on the bottom right of the section cut is drawn to scale of a food cart. All right, so we're looking at approximately 30 feet in elevation change between the parking lot level where the food cart is placed and the finished floor inside the house. It's pretty darn substantial. So in this particular case, there unique findings that can be made for this situation that don't impact the rest of the city, that because of this elevation change, we're not impacting the views or the aesthetic appeal of that house. Because of the Oregon City Municipal Code and the geological hazard that occurs on that slope or at that slope, no development can occur there now or in the future. The development that occurs not on lot 517, which I have the section through, but the one directly west of this actually had substantial limitations put on that house that it must be on the south side of that site, and they could not develop the north end of that site. The same restrictions fall on this site. The tenant for Corner 14 has discussed this proposal with both property owners to the south, and in general, they've been very supportive of everything Corner 14 has done. I believed in the last proposal. They even wrote a letter of support and said they would in this case as well, because they had no objections to what was going on. So the tenant at Corner 14 has reached out and tried to identify any areas of concern, and there has been none placed. The light pole on the northwest corner that was brought to my attention this evening, I think that's a very reasonable condition of approval. This city does have very specific lighting standards. That light should not leave the property, and that's a part of general maintenance. So if that's a condition of approval, we have no objection to that or the other condition of approval that was proposed. We have proposed some additional landscaping on site, and so that being a condition, obviously we have no objections to that. Let's see here. We've touched on there are no encumbrances on the site related to the stairs. We've discussed that the ADA parking does meet the standards as specified within the Americans with Disabilities Act. We have talked about, and if I wasn't explicit, I apologize, the parking on site. We are actually at the maximum parking. The most common public comment we get is, hey, we'd love to see more parking on site. And in fact, by the municipal code, we can't add any. We can't add a single parking spot. It is not allowed. We've discussed the 200 square foot addition on the south side of the existing building, which does not increase trip counts. It does not increase intensity of use of the site. It is simply for storage. And the mobile food carts, we're not increasing the intensity of that use either. We're simply relocating those existing ones.
Can you add a little more detail on the mitigation planting? I'm just trying to look for.
On the planting?
Explain the mitigation planting.
Oh, certainly. So we had a landscape architect take a look at the site, identify some plantings that would work well. We already have plantings along 14th Street, some seasonal plantings, some year-long plantings that occur in those planter boxes, and we'll be doing similar planters on the west side of the existing building, clearly identifying a traffic aisle versus where seating and pedestrian traffic should occur. So that's our desire, is to just beautify the site. Currently, the site is completely impervious, and with the exception of a very small amount in the southeast corner of the site, which is currently planted. And so adding some greenery is always a good thing.
There's the landscape plan is actually in the applicant's submittal, but it's just not in the staff report. And I see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 planter boxes in the area I described. And they're a combination of vine, maple, and Japanese holly and rhododendron.
Is there any way you can show us that slide? I missed.
I can, just a second, I will go over and show where it is.
Okay, I'm just curious about where those are.
Is it in the staff report?
It's in the applicant's submittal.
So I'm sure staff will maneuver towards that, but you can always open it up in your application if you like.
I don't have any other questions other than that.
It's page 55 of the applicant's submittal, I think.
I'm not pulling it up, it's right.
I've seen those.
That's on.
Yeah.
Yeah, those are,
This is a
Oh, okay.
I've seen those.
Okay, so,
You want to zoom in towards where the planter boxes are, that'd be helpful too. Maybe.
They're right there where the cursor was a moment ago.
That's okay.
That's correct.
yeah. Okay.
Yes.
I guess my only concern, and I'd like to know what my fellow commissioners think, that the big area that's partly covered and partly uncovered, when those carts move back, that area is going to be at least twice the size it is now, which to me is a big chunk of asphalt. And I would personally love to see some of those planters in that area. And I know that makes it difficult with flexibility of, where the seating arrangements are and so forth. It's just a concern that I have because, that's just going to be a big old chunk of asphalt there. So.
What I might throw out in that is we have a careful balance between cut and fill. Since this is in the floodplain, every cubic foot that we add, we have to remove. And we're very limited on what we can remove because it is all asphalt. There is no cut to occur. In many cases, you're starting with an undeveloped site. And so you can cut an infiltration basin in, for instance. When we did the addition to Lithia Subaru, we excavated on the back side of the building to create a lowered planter bed to make up for the fill that we're creating by putting in the building. In this case, we don't have really anything to remove. What's that? We could relocate some from the left side of the building towards the central seating area, if you'd like to see that. That is reasonable. We can make that happen.
Is that a permanent planter, or could it be on wheels? If it's on wheels, does it fit and code better? Could it be a planter on wheels? It's not a permanent structure?
That's a great question. We're dealing with FEMA guidelines, which is federal government, and they don't have a lot of imagination. So I'll say whatever their codes are, we have to stick to them to a T. Like, there's no flexibility in them.
Oh, I know that.
Yeah, I understand that. I like Commissioner Mitchell's ideas. If it doesn't cause more problems than it solves, if those planters are in the parking lot, the ones to the planters on the west side of the building, basically no one's going to look at besides when they're parking. And then after that, it would be nice to have some vegetation, among the seats. It wouldn't be too hard to add some, a planter next to a table or something, but just for being able to move things around, I don't think they should be permanent. Tables can be moved. If we permanently anchor a planter, I don't know if we're helping more than we're hurting at that point. But I'll let some other commissioners chime in on that.
I had actually kind of a question that affects that. Can you show us what the new egress path is in a flood and for people to come in? Is it out
certainly.
the west side or the north side, or how does that?
So it occurs between the building and the food carts on the south. We've got a width there that's suitable. The maneuvering happens out where the seating is, and then the drive out is nice and clean. So
Where it says seating and then there's two landscape boxes?
Yep, right through.
So are those landscape boxes able to be moved then?
They will have to be movable. Those are there to prevent car traffic from accidentally driving into the seating area.
Okay. I just want to make sure we don't add a condition that interferes with that benefit.
Thank you.
Okay, so we already have some movable planters.
Well, Chair Schlagenhofer?
Yes.
So they're on the other side of the building, though, to protect the difference between parking, and so cars don't park in too close to the food. So they serve a very useful purpose on the other side,
Okay.
other than a decorative.
Okay.
But I think you could still accomplish that without having a solid wall, which is what it looks like here, and maybe move half of those over into the big asphalt area, just to break it up a little bit.
And we'd be happy to relocate, let's say, half of those to be in or around the seating area, in the centralized seating area.
Okay. But somewhat movable so they don't obstruct being
Well,
able to pull the carts out?
I think that would be up to the landscape architect. Better to make that decision than me.
Okay.
I
So
would
if
say
it's-
they will be movable. They would have to be, but we would accommodate that.
Yeah, or it would cause more problems.
Yeah, we don't want to cause problems, but we want it to look nice. So, would everybody agree on that? Move half of them as long as they're not causing any problems? Okay? I don't know how to condition that.
6.
We can do it, okay. All right, any other concerns? Yeah, mine have all been answered. Okay.
Then I will, if nobody else.
Hold
Sorry.
on. We need to make sure that there's no one, thank you. Okay. Anyone from a neighborhood association, public entity, any public comments? Anyone out there?
No, there are none online.
Okay, so since there's no public comments, there's going to be no need for a rebuttal. Okay, finally, nothing else? Okay, so we're going to close the public record, and we can deliberate, or we can have a motion.
And I have a recommended revised condition of approval based on conversation if the planning commission wants to hear that.
Okay, great, let's hear it.
So condition of approval number 6 said the applicant shall ensure that the proposed landscaping planting proposed in the previous application is installed prior to obtaining a final building permit, and we'll add an additional sentence clause to that. At least 6 planters proposed shall be relocated to the seating area. Is that, if I say seating area, is that assumed we know that between, seating area between the main building and Washington Street? Is that anywhere in that area or more specific?
The southern part, does that sound right?
Well, it may be with 6
My
of them.
intention was just in that area.
Just somewhere in there, okay.
Yeah.
My worry is that 6 may be hard to fit in there rather than 6 generally on the between the building and the
And Washington.
Washington Street.
Right.
Okay,
Okay. So the seating area between the main building and Washington Street.
and that's condition 6?
Yep, as revised.
Okay, with revised condition 6, okay. All right. So can we have a motion?
I will make a
Addressing-
motion. Sorry.
Addressing condition 6 of revised as Ms. Robertson Gardner has suggested. Okay.
I'll make a motion to approve GL UA 22-15, SP 22-50, and VAR 22-2, and FP 22-2 with revised condition number 6 and with the other conditions as presented by staff.
Great. Okay, we have a motion. Do we have a second?
Second.
Okay, got a motion by Commissioner Mitchell and a second by Commissioner Stoll. Can we have a vote, please?
Commissioner Greg Stahl?
Aye.
Commissioner Daphne West?
Aye.
Vice Chair Mike Mitchell?
Aye.
And Chair Dirk Schlagenhofer?
Aye. Okay, motion passes. All right, that is the end of our public hearings. Do we have any communications?
Just a couple of things. At this point in time, we don't have anything scheduled for our September 26th regular meeting, so I believe we'll be canceling that. And then, so the next time we'll meet will be on October the 10th, when we have a work session, and we'll have 2 items to discuss. One is a review of the types of land use decisions we have, and who makes a decision and why they are the types that they are, I guess you could say. And then the second piece, I'm hoping to bring back the OC 2040 comp plan in more of a graphic format. And then I'll be asking at that point if you're ready to move into adoption proceedings. And there is a regular meeting that night as well. I think we have 2 items, so at this point, no meeting September 26th, so that you can be refreshed and geared up for October 10th. That's all for my communications.
Okay, thank you. And I believe Commissioner Stoll had something he wanted to bring up.
Yeah, I have 2. I'll start with a quick one. Over the last couple of years, we've had a lot of testimony regarding egress and emergencies with wildfires and things. We can't act on that because there's no code. I know in Central Oregon, some of the municipalities, Bend specifically has that in their code, and I'd like to, whenever, the next code revision, whenever it's appropriate, see if we can visit that and if we can add that to the code, because it's becoming applicable.
Do you know where, do you have an example of what Bend is doing?
I don't. I have a friend that I can get it. I have a friend that used to work for a developer, and so he used to deal with it, and I can
That'd be great.
figure it out, yeah. Secondly, it up here. I just had it. Article 3, Section D of the Planning Commission bylaws. Upon a finding of misconduct or non-performance of duty, the Planning Commission may recommend termination of that appointment to the City Commission, and the City Commission may remove the incumbent from the Planning Commission after a public hearing and declare the position vacant to be filled in the manner of regular appointment. I don't expect a decision tonight. I'm going to lay out my case right now. I'll put it in writing before we discuss it, but I'd like to have this discussed in the near future. Commissioner LaSalle's behavior in the last hearing, as well as tonight, I think constitutes a non-performance of duty. Tonight, he believed he had lost, or that the motion had passed, and he got up and left, which is completely inappropriate. Once he realized the truth, he came back, sat for another vote, and then left again when it was determined that he did indeed lose the motion. He had declared no bias throughout this entire proceeding, but I think his behavior demonstrates that he had a personal interest in the outcome of this hearing, which constitutes bias. In the last hearing, Commissioner LaSalle asked a number of questions that had been answered completely adequately by the staff. Whether he was trying, I don't know what exactly the purpose of that was, if he didn't hear it, if he didn't comprehend those questions, if he wasn't paying attention to hear those questions answered by staff without having to bring it up to the applicant and use up time. And then again tonight, he didn't comprehend the results of the vote. I don't know that he has the capacity, and I'm not going to say it's physical or it's mental, I don't know. I don't know that he has the capacity to serve on this commission anymore. That's it.
Okay, so legal question on that topic. I believe that would have to be a public process? Or do we have to have a meeting on that? Is that what was in the bylaws? We just went through them.
That's my understanding as I read the bylaws.
Public meeting with the full commission?
I would certainly hope a full commission.
Okay.
But I think it's, and I'm sorry about the 26th, I think it's important to have that before we decide on anything else going forward involving, if Commissioner LaSalle is to attend.
Okay, how do we such a process? I believe the bylaws spell it out. Oh, good. Mr. Kabizman is still with us.
I am. I was listening throughout all the interesting things about Corner 14 and stuck around for the whole thing. But in terms of initiating, it sounds like Commissioner Stoll has more or less initiated it. What would be appropriate would be at some point to, a member of the commission to make a motion to recommend to the city commission whatever action the planning, that commissioner, everything, and I think it's appropriate to also give Commissioner LaSalle an opportunity to respond at the planning commission, but at the next meeting or meeting after that, a commissioner can make the motion to make that recommendation to the city commission.
And as I'm reading the bylaw, as I'm reading the bylaws, it says, upon a finding of misconduct or non-performance of duty, the planning commission may recommend termination. So I read that as we would initiate the process by the commission finding that there was a non-performance of duty and then forwarding it. And I'm happy to put these under writing. I intend to before the next packet goes out.
That's correct. To the extent a planning commissioner believed that there was misconduct or non-performance of duty, that they would make the motion to the planning commission during a meeting saying, I'm going to make I move that we make a recommendation to the city commission to remove, whatever commissioner for misconduct or failure to perform the duties.
Okay. As for my personal thoughts on this, I feel like it should be the full commission making this decision.
I'm certainly not asking for anything tonight. I'm just.
Right, no, I know you wanted it to be.
Well, full commission minus Commissioner LaSalle. I don't think he should be able to.
Commissioner LaSalle would not be qualified to vote on a decision on his, whether he was
status,
conducted.
And he does have a right to speak and explain his situation. So, okay, since we don't have everyone here, is it the time to make the motion? Or
no, I'm bringing it up now.
Meeting?
I'll put it in writing and I'll make the motion.
At the next meeting when we have
the next meeting,
full commission. All right, okay.
Whether, I don't know if you want to, if we don't have anything for September 26th, we can move to the next one, but I don't know how full that is and how, anyway.
Okay, so follow the process.
Yep.
We can schedule it for September 26th. The only reason that I wasn't going to have, that I was intending to cancel that was because of lack of agenda items, but this would be an agenda item and it might be more appropriate to just have this on the agenda, so.
Yeah, as much as I would love to not, not be here in 2 weeks, I think it's important to take care of this before we have another hearing.
Okay, I can agree with that. Commissioner Mitchell?
I have nothing on that. I have something else.
Okay. All right, would you be agreeable to coming back in 2 weeks for that agenda item? Okay, all right, I think we can all agree on that. And then you have something else?
Yeah, just a question, how we handle public notification, and it came to mind with the application that we saw tonight, which is right on the border between the Three Rivers, or Two Rivers, 2 or 3, whichever it is, Neighborhood Association and the McLaughlin Neighborhood Association. Their public meeting was before the CIC because that neighborhood association isn't active. So I guess my question is, when we're that close to another neighborhood association, do we notify that neighborhood association as well?
I'm going to let Christina answer.
We do, and it's by policy.
Okay.
Actually, policy through our Handy GIS program. So when I do public notice, I create my little labels through our GIS program. It pops up a question and says, do you want to send this to the neighborhood association and abutting neighborhood associations? And I say, yes. And then the addresses that have been given to us by the neighborhood associations are added to the public mailing. So
okay.
the address is given to us by the neighborhood associations, usually it's the land use chair or the chair, is added into our database for public comments for neighborhood associations.
Okay, so does that second neighborhood association have to be directly abutting the property, or is it within a certain distance?
I think it is a certain distance, because I know I've had a fair amount of noticing, and that pop-up came and I went, oh yeah, sure. And so whenever the pop-up, I always say anything abutting. So it could be, we can verify it a follow-up email, but I've had ones that are like quarter miles and 2/3 mile and a mile away that have had the abutting neighborhood association be noticed.
Okay, yeah, I would like to know.
Yeah, it's,
on that.
I don't know the specific answer, but we do often send emails to abutting neighborhoods.
Good,
I
thank
mean,
you.
sorry, not emails,
Postcard.
the notice,
Yeah.
the mail notice.
To the neighborhood association, yeah.
And then when we do a transmittal, our email transmittal gets sent to the neighborhood associations.
Okay, thank you.
Okay. Any other items to discuss? Okay, we're adjourned.